Good friend from South Carolina, Mr. Norman. Thank you. I would yield to Ms. Ledger-Fernandez for any questions she might have.
No, sir.
Thank you very much. I feel like am I having any takers? I would yield to Mr. Roy.
I'm sorry. I'm taking. Just really quick, Mr. Chairman, to your point, is it not true that a significant number of states and districts across the country, regardless of their political makeup, red state, blue state, whatever, get judges under this legislation?
Yes, and I would, yes, that's definitely the case.
Right. In other words, in the conversations and the debates between Democrats and Republicans on something that is inherently political, despite the fact we pretend that the judiciary is not political, as evidenced by this exact situation that my colleagues on the other side of the aisle don't want to put forward more judges now that they know President Trump has been elected for 4 years. So the non-political judiciary is clearly inherently political. So the question here is, there was a debate and legislation was put forward, general agreement to put it forward, and it was designed to create new judgeships throughout the country. And I frankly don't have it. It's 60-something judges. Is
66.
That what it is? 66 judges, and I don't know, to be honest with you, how that's parsed out. I couldn't tell you whether, I know Texas gets some.
Yep.
And I know there's other states, but I don't know whether there's any, for example, the gentleman from Colorado and the gentleman lady from New Mexico. I don't know how they're parsed out. My point is, and it could be tilted one way or the other.
California gets 7, and
Okay.
again, two Democrats. And I actually had Republicans come up to be concerned that they actually wanted to look to amend the legislation because they were concerned about all the states where both senators are Democrat. And we all know how this process works. Democrat senators weigh in with the administration when they're determining who are going to be federal judges in those respective states.
So, I mean, I think suffice it to say, I mean, and the ranking member said that that's why this bill should not pass, is we now know the result of the election. But if the judges are needed, the judges are needed. True? Is that right?
Accurate.
I mean, would the ranking member agree, regardless of the ranking member's concerns about the extent to which we now have 4 years of a president not of the liking of the ranking member, that in fact we still, for purposes of managing the caseload and the workload, say as a former AUSA and appearing before judges, that we do need the judges? Do we all agree on that on a bipartisan basis, that we need the judges?
If you permit me to comment, we need the number of judges. However, President Trump has shown, he bragged that by his 3 appointments, he overturned Roe v. Wade. He said he was going to do it, he did it. So don't tell me it's not political. Now, you may think overturning Roe v. Wade is a good idea or a bad idea, but it was certainly a political idea. He promised to do it. He appointed 3 judges whom he knew would do it. They did it. And that's the way, unfortunately, the process works.
Would the ranking member agree that the truth is, over in the Senate, in particular, between the blue slip policy and the way we handle the circuit judges, that is different than the way we handle the United States Supreme Court? In other words, the local senators have a significant say, and the Judiciary Committee and the Senate have a significant say.
You do not know, Mr. Roy, if President Trump, who has proven to be iconoclastic in many ways, will adhere to that practice or not. He is not bound by it by law. It's custom. He may decide no.
But the truth is, having served as a lawyer on the Senate Judiciary Committee, that is the way that has typically been done. And would the chairman agree that that is the way it's typically been done, that that's the way we would expect it to be done? Obviously, that doesn't mean that a senator gets a hardcore
Right.
decision point to be the one person who decides, but that general respect and comity is yielded to the senators in question. So to the extent that there is a judge being added in a jurisdiction, say the California jurisdiction, that we would, generally speaking, have some deference to the California senators. Is that not what we would expect? Frankly, to our chagrin, right? Would the chairman agree with that?
Yeah, and frankly, we're talking about judges, but that typically applies to U.S. attorneys as well. I mean, they weigh in on that also in our judicial system.
I'd point out
Yeah, sure, the ranking member.
that blue slips were changed for circuit courts in 2017.
I would
So it doesn't even apply to circuit courts.
I would point out that it was, in fact, the Democrat majority leader that opened up that can of worms.
That may be.
As is well
That may
documented
be.
historically.
That may
So,
be. I'm not,
so
I'm
my
not saying
point.
it's a good thing or a bad thing to do. I'm simply
We are-
saying it's
We are where
done.
we are, as I would say the right member. So, Mr. Chairman, the only other point I would make to the chairman, there's one other issue that I'm not going to focus on in a significant length, but there is the issue that I think is important with respect to the current Senate leader, Mr. Schumer, engaging and focusing and targeting and sending a letter to a particular district, one that happens to be in the state that I represent, although not in the district I represent, in the Northern District of Texas, where Senator Schumer injected himself in the way and the nature in which cases are assigned. And I've had some correspondence back and forth with the courts and with the administrative office of the courts about this issue. And I just wonder if the chairman agrees that under our current statute, our current law, that we should not try to force upon by some edict by the judicial conference that would supersede the statute that says that judges
Right.
should make the determination in the districts on where cases are assigned, that there shouldn't be a random process, literally a randomized process laid on top of that through rulemaking by the courts. That if we were to choose to do that as Congress, we are well within our powers, Congress, to do that, but it is not the courts that should do that on top and overlay
Right.
the statute.
Totally agree. Totally agree.
That is
And that was
something
one of the
that I-
issues we were debating in the context of this larger debate on this bill, and frankly, another bill that came from the Senate that I think is going to get made into law as well.
Correct. Well, with that, I will yield back.
Thank you, Mr. Roy. And I would yield to Mr. Langworthy for any